Hi, and welcome to this latest immigration law conversation. Today, I have the privilege of being joined by Priya Solanki. Priya is a barrister, and we're often seen together doing update events for solicitors and lawyers on immigration law. And she's agreed to come along today to talk about her new book on challenging sham marriage allegations in immigration law. So, Priya, thank you so much for joining me today.
You're very welcome, Adam. Thank you so much for having me.
So we wanted to have a talk about your book, but just to remind people, these videos are not legal advice. They're for information purposes only, and we hope they're helpful. But Priya, for somebody who doesn't know you, tell us a bit about you and what you do.
Sure. So I'm Priya Solanki. I'm a barrister at One Pump Court Chambers in London. I've been practicing in immigration and asylum law for about 12 years. I used to work at an asylum charity, and then I worked in private practice in immigration, and then I came to the bar. And I have quite a broad practice in immigration and asylum, dealing with deports, trafficking, detention, EU cases, family and private life cases. As you've already said, I do a large amount of training, seminars, webinars with yourself. And I'm also a mum of a 2-year-old and a 4-year-old.
Fantastic.
Which is a job in itself.
Absolutely, absolutely. In terms of, well, I'm surprised you got time to write this book, absolutely, with all that going on.
So am I.
This is about challenging sham marriage allegations. So let's start at the beginning. What is a sham marriage, or the Home Office sometimes talks about marriage of convenience, and actually, is there a difference between those two things?
Okay, so there is a difference, which is quite surprising. So a sham marriage is defined under the Immigration Act, and it's a marriage in which, or a civil partnership in which there is no genuine relationship between the parties, and either one or both of the parties would benefit from the marriage or civil partnership in terms of immigration. And then in contrast, a marriage of convenience is defined as a marriage entered into for the purpose of circumventing immigration control. Now, one can see the immediate difference between those two is in sham marriage, there's reference to genuineness. Is this a genuine couple or not? And if they are, then they can't be in a marriage of convenience, but if in a sham marriage, sorry, but if they are not in a genuine relationship, then it follows that they're in a sham marriage. Because genuineness is missing from the term marriage of convenience, it leads to a situation where a couple in a genuine relationship could be found to be in a marriage of convenience. And a very good example of that, Adam, is in a case called Melina, where they had been in a genuine relationship for quite some time, and the court in fact said that it was a genuine relationship, and that meant that it couldn't be a sham marriage. But they said that the parties were aware that they would benefit from it, the marriage in immigration terms, and it was considered that that meant that they were in a marriage of convenience. Now, fortunately, that was a case that was appealed to the Court of Appeal, and it's settled, and the consent order is available online. But the case does really highlight that it could catch out this difference in the definition. It could catch out many genuine couples.
That's really helpful. And as I was looking through your book today, you've set out parts of that consent order because it was done, Melina was done by consent in the Court of Appeal. And I thought it was really helpful, and people might want to have a look at that and refer to the consent order, because that is set out and provides some helpful stuff. In terms of the Home Office sort of infrastructure, then how do the Home Office go about investigating suspected sham marriages?
Okay, so since March of 2015, they've put in place what's referred to as a referral and investigation scheme for proposed marriages and proposed civil partnerships in the UK, which involve a foreign national who could benefit in immigration terms. So basically, Adam, a proposed marriage or civil partnership will automatically be referred to the Home Office by a registration official if it involves an individual who will benefit in immigration terms. Now, that definition of who will benefit needs to be considered in some detail, and I've set that out at quite length in the book that you have held up. But the scheme has several parts to it. So firstly, there will be a referral to the Home Office by the registration official if it involves the right type of person. Once a referral is made, the Home Office have to make a decision whether or not to investigate that marriage or civil partnership. If they decide to investigate it, what happens is that the notice period for the marriage is extended. And in that notice period, they will investigate the relationship. If, however, they make a decision not to investigate, then the couple can go ahead and marry or enter a civil partnership. In the situation where they're investigating, the couple can be invited to provide further evidence. They can be asked to provide photographs, for example, specific evidence relating to cohabitation, and more often than not, they're invited to some form of interview. So that can be by phone, by video, in person, and it can also take place in situations where they're detained by the Home Office. Now, after that investigation has taken place, they will make a decision as to whether or not the parties have complied with the investigation. If they have, then they'll be permitted to marry. And if they haven't complied, then they will receive a decision that says that there's been non-compliance. The registrar will be informed and they won't be permitted to marry. Now, it's far more complex than that, and the book goes into a lot of detail about time limits, etc., and how that's important. But that's it in a nutshell, Adam. Now, investigations can also occur outside this referral and investigation scheme. So say a couple so an individual enters a relationship with a British national, and then they decide to make an application to the Home Office based on that relationship. That application could trigger an investigation, and it might lead to the Home Office asking for further documents, or indeed visiting a premises, or asking for the parties to attend an interview.
You've talked about interviews a couple of times, and I suppose when we deal with appeals involving sham marriages, it's often based on those interviews, perhaps after a marriage has taken place and sort of precipitated by an application by one of the parties. The Home Office often base their decisions on discrepancies between the partners in the marriage interviews. I know we're both smiling at this point because we've come across it lots of times, but what issues do those marriage interviews, forgive me, throw up in appeals?
Okay, so I think the most important thing with marriage interviews is to, if you have notice of it, for you and for the clients and the legal representatives to really prepare for an interview. Now, that means making sure that there are proper procedures in place and that the Home Office is complying with those. And that might include you asking the Home Office to tape record an interview to make sure that there's an interpreter in place. Now, often clients worry about asking for interpreters because they worry that if their partner are speaking a different language, that will mean that it's concluded that they're not in a genuine relationship. But interviews are really nerve-wracking situations, and that can be explained in advance, and it can be said that whilst they speak the same language, for the purposes of the interview, it's really important they're able to speak in their main language so that they're able to properly express themselves. It's also important that they think about submitting in advance documentation that shows that they're in a genuine relationship, and that they are aware that this is an interview that could later be held against them, because I'm not sure that many clients that attend these interviews think about it in that way. And if they do think about it in that way, it means that when they are being asked quite difficult questions, or that they don't understand a question, they can tell the Home Office that, and they can ask for things to be repeated or phrased in a different way. The other thing that can happen when there's notice of an interview is that a legal representative can actually be present, and they can take a contemporaneous note of what's happened there. Now, after an interview, it's really important that the parties ask for the written record of it, and they should really be asking for the verbatim record of the interview. Now, you should be really pressing the Home Office for that, and in circumstances where it doesn't appear very quickly, that can be something that you can raise in a challenge later on. But if it is provided in good time, it's really important that representatives go through that interview with the client, and that the client is able to tell them very quickly after an interview whether or not what's written down in there actually reflects what they said. And they're not going to remember that in 6 months or a year's time. I mean, some might, but many won't. And I think it's all of those things that can really assist clients. Now, the other thing that I will say before moving on about interviews is that often the Home Office don't serve an interview record at all, and what they serve is a summary of it. Now, one person's summary of an interview can be very different to another person's summary, and in those circumstances, it's really important that there is real thought about whether the summary is what your client remembers about that interview. And if it's not, that needs to be really challenged, and you need to push for a fuller record or make subject access requests to see if you can obtain anything further. A good case to refer to in respect of interviews, Adam, is the case of Sadowska. It's a case where the parties to the marriage were saying that they felt that the interview had been quite oppressive, that the circumstances in which it had occurred hadn't been very fair. It wasn't taken into account by the tribunal, but when the case was appealed, the Supreme Court said that those circumstances had to be taken into account in looking at the answers that they provided.
That's really helpful. And I think Sadowska is so helpful in talking about looking at the answers they got correct as well as the answers that are wrong, because often you get these refusal letters that cite 10 or 12 examples of discrepancies. And then when you finally get the full transcript, there are 300 correct answers which nobody's thought about and put into context. No, so that's some really helpful guidance in relation to that. In terms of legal tests, I know as lawyers sometimes we get excited about legal tests, or certainly I do anyway, but what about the burden and standard? Who has to prove a sham marriage, and to what level do they have to prove that?
Okay, so I'll keep it simple for these purposes, but it's gone into in a lot of detail in the book. So it's well established, including in the decision of Sadowska, that the burden of proof for establishing that parties are in a marriage of convenience, that rests with the Secretary of State. And the standard of proof is the balance of probabilities. Now, that balance of probabilities test is summarized really well in a case called Papageorgi. It's a 2012 tribunal decision, and I'll read out exactly what's said in there actually. In light of the totality of the information before me, including the assessment of the claimant's answers and any information provided, am I satisfied that it's more probable than not that this is a marriage of convenience? As I say, Adam, the book deals with it in a lot more detail and deals with a lot of case law on it, but there it is in a nutshell.
I think that's helpful, that phrase, the totality of the evidence, because there's that temptation, isn't it? We've talked about, say, discrepancies, to focus on those narrow issues and not, Home Office or judges not to weigh up all of the evidence in that assessment of whether it's a sham marriage. Just as we come towards a conclusion, just in terms of practical steps, you've talked about practical steps in terms of interview and preparing at that pre-interview stage. What about at the appeal stage? Are there some practical tips you'd suggest for lawyers in challenging sham marriage allegations?
So if you haven't received evidence from the Home Office that supports the allegation that it's a sham marriage of convenience, that's your starting point. The burden is upon them. If the evidence hasn't been produced, then that should be the end of the case. Now, often they do turn up very late in the case with evidence, and often that happens on the day of the hearing. If that happens, then you need to consider that evidence very carefully, and more often than not, it's very likely that an adjournment will be required for your client to be able to properly address that. The other thing that I would say in terms of preparing for appeals is witness statements need to be drafted with real care. The court are looking at what the predominant purpose of a marriage is. Now, Adam, me and you know that there can be hundreds of reasons why people marry. It might be religious reasons, cultural reasons. It might just be that that's the natural point that their relationship is reached. It feels like it's the right thing to do. It can be really difficult to explain actually why it is that couples are marrying, but the words that are used in a statement need to be considered with real care, because often the wrong word might lead to the Home Office saying that the predominant purpose was indeed immigration purposes. The other thing that I would say is that supporting statements from friends and families, evidence that post-dates a marriage interview, that can be important because it sheds light on the whole situation of the relationship. And another useful thing I would say, Adam, is that practitioners should make use of the Home Office family policy guidance. Yeah. What that does is it sets out factors that are associated with a genuine relationship, and it sets out a range of factors that are associated with a non-genuine relationship. And if practitioners can familiarize themselves with those factors, it means that they will be able to present that sort of evidence to the tribunal and then refer the court to that evidence and say, well, actually, this is what the Home Office say is associated with a genuine relationship, and it appears in this case. So that should mean that this is a claim that should be accepted. Hopefully that's useful, Adam.
Yeah, no, that is useful. And what I'll do, I'll find the family policy guidance and link it under the video, because I think that it is really helpful. And perhaps it's a way, you know, in today's sort of appeal regime, when appeal skeleton arguments are so important, that may be a structure that somebody can use when making their submissions within the appeal skeleton argument, to use those sort of factors as a framework in terms of saying, well, look, these are the factors they look for, and this is the evidence that points towards that. So no, I think that's a real helpful tip. Now, obviously, the other practical tip is to get your book. So just finally, if people, I'm not on commission, honestly, but if somebody wants to get a hold of a copy of the book or find more out about it, what can they do?
So Waterstones, Wildies, Amazon, that's a few of the places that the book's available. On the Law Brief Publishing website, and those are the publishers of the book, there's a free chapter that's available as well. And I am doing a full seminar on sham marriages with MBL later this year. So if people want to join that as well, then that would probably be useful in looking at all of this in some more detail.
No, that's great. And I'll put the link to Law Brief Publishing under the video, and also a link to the page where you can get the free chapter of the book. So that's great. Priya, thank you so much for putting up with my questions this afternoon. That's really helpful. And thank you for joining me. I think it's a really helpful book. And it, you know, these are important issues that sometimes, you know, things are not dealt with properly in sham marriage allegations. Evidence is not demanded from the Home Office, and the cases are not properly considered, and sometimes you pick them up when there's already been negative findings and you're trying to repair the damage. So if people can prepare and be armed in advance, I think that's so helpful. So thank you so much, Priya.
Thanks, Adam.